portion of the mock test 2. Now, as we know, the second mock test was based on the lines of IRET paper, that is a National Law University Delhi pattern. So moving on to the legal section, we can see that section C was the legal aptitude section and started from question number 71 up till question number 105. It had 10 questions of legal knowledge and rest 25 questions of legal reasoning. So starting with the legal knowledge question, the answer for question number 71, the correct answer is A, that is amicus curiae. Then moving on to question number 72, the correct answer for question number 72 is option B. Moving on to question number 73, who was responsible for introduction of PIL in India? The correct option in this question is option number C. Moving down to question number 74, the correct option for this question is option D. Question number 75. This was a little tricky question when it came to the legal knowledge questions. A lot of students have marked D also as the answer for this particular question, but the correct answer option is option B. Moving on to question number 76. The correct answer is option B. Then moving on to question number 77. The correct answer option is option D, both A and C. Question number 78. Again the correct answer option is option B. A criminal conduct is when the damages are awarded but not in a criminal conduct. Moving on to question number 79. De minimis non curat lex. What does this refer to? So this particular maxim refers to option A, that is the law does not concern itself with trifles. Moving to question number 80. What is a tender? A tender is an invitation to offer. So therefore the correct answer option is option D. Going ahead to question number 81. Again this was one of the difficult questions. A lot of students have marked option A as the answer, but when an offer is addressed to the public at large, it is called a general offer. So that is why option C is the correct answer. Now coming down to question number 82. When the owner of a plot gives advertisement in the newspaper, again this is something which is an advertisement. This would amount to an invitation to offer. Therefore option B is the correct answer. Coming down to question 83. A contract is dash when in the mind of each contracting party there is a consensus addendum. So when there is a consensus addendum, the contract is concluded. Therefore option A. Next, question number 84. The decision of Muri Bibi versus Dharmodas Ghosh is a very famous case, and this deals with the capacity of a minor to enter into a contract, making option D as the correct answer. Then going ahead to question number 85, the last question for the legal knowledge part, that is the preamble of the constitution was prepared by whom? Again maximum number of students have marked D, that is B.R. Ambedkar as the option, but this question is referring to the preamble of the constitution, and that was prepared by Pandit Jawaharlal Nehru. Therefore option A is the correct answer. Now we will move ahead to the legal reasoning questions. Coming down to question number 86. A lot of students, the legal reasoning portion in total was of a very good standard. There are around 10-11 questions in which students have marked other options other than the correct answer. The maximum number of students marking the other options as the correct answer but not the actual answer. So as we go on discussing questions, we will understand that how can we better understand the reasoning portion with this analysis. So as we see in question number 86, in this particular question, maximum number of students have marked C as the answer, that Rosie's promise is merely a gratuitous promise. Now let's go in detail about the question. In this particular question, the principle is when at the desire of the promiser, the promisee has done something. Such an act is called a consideration for the promise. So in the facts, we see that Rosie is a wealthy widow and was approached by a university for a donation that the school wanted to use for constructing a hostel for women. Rosie offered to donate an amount that would cover 50% of the capital required. Now this fact does not say that these people have started doing anything. The question that is being asked is, if Rosie were to refuse later, can the university sue her to pay? So this thing has not happened, but the question that is posed is, if Rosie were to later refuse, can the university sue her to pay? So as of now, the university has not done something on the desire of the promiser. The promisee has not done something if we look at the principle. So option C says that no, Rosie is not liable to pay because Rosie's promise is merely a gratuitous promise. But if we look at option B, it says yes, Rosie will be liable, but if the university can show that they commenced the construction of the hostel relying on Rosie's promise. So this option is going exactly on the lines of principle 1, which says that when at the desire of the promiser, the promisee has done something. So option B, if you see that if the university can show that they commenced construction of the hostel relying on Rosie's promise. So this will go exactly with the principle when it says when at the desire of the promiser, the promisee has done something. So that is why the correct option for this particular question is option B, that she would be liable to pay, but when, if the university can show that they commenced the construction of the hostel relying on Rosie's promise. So therefore option B is the correct answer for question number 86. Coming down to question 87, most of the students have attempted this question correctly. So for this particular question, we have option A as the correct answer, that Roshan is not liable even though Raj suffered a loss. Roshan has merely exercised his legal right to dig the well in his own land. Moving ahead to question number 88. This was again a slightly tricky question. Now in this particular question, most of the students, the majority has marked A as the correct answer, maximum number of students. And apart from that, the second most opted answer is option B. Now let's look into the details of this question. Now this question says that the principle 1 says a proposal may be revoked by the lapse of time prescribed in such proposal for acceptance, or if no such time is so prescribed, by the lapse of a reasonable time without communication of acceptance. Okay, this line is important, without communication of acceptance. Principle 2 says the communication of acceptance is complete as against the proposer. Proposer is a person who is giving the offer, who is proposing something. So the communication of acceptance will be complete for the proposer when it is put in the course of transmission to him so as to be out of the power of the acceptor. So when the acceptor puts the acceptance in the course of transmission towards the proposer, as soon as the acceptance is put in course of transmission, the communication of acceptance is complete. Now let's look at the facts. The fact says A offered to sell his Mercedes to B for rupees 15,000. A 13 July 2013, wherein it was stated that the offer must be accepted within a week. B received the letter on 15th July, that is just after 2 days, and on the same day he posted his assent. Posted means he has put in the course of transmission via mail. As there was a strike by the postal employees, the letter could not reach A till August 13, 2013. On August 5, after waiting for almost 3 weeks for a reply, A sold his Mercedes to C. Now B initiated action for the breach of contract against A. Now, from the facts, we can easily see that the communication was sent by B on the same day. It was put in the course of transmission, and principle 2 says the communication of acceptance is complete as against the proposer when it is put in the course of transmission to him. So, as B has put the letter in the course of transmission, the communication for the proposer stands complete. What does principle 1 says? It says a proposal may be revoked by the lapse of time prescribed in such proposal for acceptance, or if no such time is so prescribed, by the lapse of a reasonable time without communication of acceptance. So, first of all, there is no lapse of that prescribed time. A said that sent me the reply in 1 week's time, and B has posted the acceptance on the same day. So there was no lapse of time. And even if we say that there was a lapse of reasonable time, but principle 1 says that the lapse of reasonable time should be without communication of acceptance. Over here, B has given his communication of acceptance, and as soon as he has put it in course of transmission, it also stands complete for A. That is why in this case, when B initiated an action against A will be liable. He will be held guilty for breach of the contract. So that is why the correct option for this particular question is option D, that is none of the above. Because all the three options A, B and C, they say that A is not guilty. But we can see that from the principle he is guilty for the breach of contract. Therefore, the correct answer is option D. Now, moving on to question number 89. Question number 89 is a question on constitution. Again, in this particular question, students have marked A, B, and D as the answers. A, C and D. This is the majority of the students, almost equal number of students have marked all three of them as the answers. So, let's see what does the question say. The question says, it talks about Article 15 Clause 1 of the Constitution, which provides that the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth or any of them. Nothing in this article shall prevent the state from making any special provision for women and children. Alright. Principle 2 says, as and when any reservation is made in favor of women, the same should be tested on the grounds of reasonableness. Fine. Now what does the fact say? The fact says, looking at the number of rape and sexual harassment cases in colleges, the Rajasthan University passed a rule barring a male lecturer from being appointed as principal in girls' colleges in the state of Rajasthan. Now, Ashok, a male professor who wishes to apply to a girls' college for the post of principal, challenges this rule as against Article 15 Clause 1 of the Constitution. Now, when we look at the facts, the first thing that we see that there is no reasonable ground for barring a male member from being appointed as the principal of option D, both of them say that the rule is violative. Option D says the rule is violative of Article 15 clause 1 of the Constitution of India as it wasn't necessary to form such a rule. A female principal cannot necessarily prevent all rapes and sexual harassment in colleges. Now the reason that they have given in option D, that a female principal cannot necessarily prevent all rapes and sexual harassment cases in college, is not going along with the first part. We do not know that if whether a female candidate, a female principal can prevent such cases or not. We do not know about it. The principle or the facts nowhere state such a reason. But option B, what does option B says? That the rule is violative of Article 15 clause 1 of the Constitution as there was no reasonable ground or criterion for such a rule. So that is why for this particular question, option B is the correct answer. Now let's move on to question number 90. Question number 90 is a question on the topic of thoughts. Again, this has been a debatable question and majority of the students have marked A as the option, that the godown owner is not liable for causing nuisance because he is not harming or damaging Mr. Weasley's property. Okay. Now, let's go to the principle first. Principle says in order to entitle a person to maintain an action for damage caused by a nuisance, the damage must be particular, direct and substantial. Now nowhere does it say that the action or action for damage, it needs to be physical. The principle does not say this. The principle merely says that in order to entitle a person to maintain an action for damage caused by a nuisance, the damage must be particular, direct and substantial. These are the three requirements for the type of damage which should be there. Now the fact says Mr. Weasley owned Just Coffee Cafe, which served all kinds of coffee and had a countrywide specialities and was a favorite hangout of all coffee lovers. The adjacent shop was a godown for keeping agricultural produce. Horses used for delivery of goods to the godown often obstructed access to the local shops and the smell of the urine was strong. Mr. Weasley suffered a loss because the smell of the horses put off the potential customers. Okay. Moreover, the accessibility and view of his shop was also hindered. So accessibility, view of the shop was also hindered because of the horse carts. So we can see from the facts that his potential customers were put off because of the smell of the horses. Secondly, accessibility of his shop, the view of his shop, the customers, the potential customers were not even able to have a look, could not even see his shop being located at that place. So that is why we can see that there was a particular loss and a direct and a substantial loss. Particular means the potential customers being put off. Particularly he is talking about his the business that he would be losing out. Direct, because people were not able to access the shop, he was getting a direct loss. That was because of the horse cart. It was not that the horse cart were placed there and because of some repercussion he suffered some loss. No, the horse carts were standing there and directly because of it, because the view was hindered, because the accessibility was hindered, there was a direct loss. And substantial, because his potential customers were let off, he had a substantial amount of loss, the monetary loss. So the principle does not say there has to be a physical loss. The damage should only be particular, direct and substantial, which we can see was happening in this particular case. So now we can see that there was loss. That means the godown owner is liable. For the liability of godown owner, we see that C and D, both the options says that the godown owner is liable. option D says the go down owner is liable for causing nuisance because he opened a go down in the main marketplace, causing trouble to the other shopkeepers. So the reason for his liability is not because he opened a go down in the main marketplace. The reason was the horses. Okay, so the reason mentioned over here in option number D is not the correct reason for his liability. Now option C. What does option C says? The go down owner is liable for causing nuisance because the damage caused to Mr. Beasley was direct and substantial. So as per the principle, we can see that option C is giving the correct reasoning. That is why option C is the correct answer. Now let's move down to question number 91. Question number 91 was a moderate question on contrast. Most of the students have marked it correct, and the correct answer is option A. Next, we move down to question number 92 and 93. It has a common principle and facts. Now again, both these questions are very debatable questions. Students have marked option D. The majority of the students have marked option D as the correct answer for question 92, and for question number 93, most of the students have marked B as the correct answer. Now let's see the principle and facts. Principle says the Constitution of India guarantees to all citizens the right to freedom of speech and expression. Reasonable restrictions can be imposed on the right for certain purpose, such as the interest of sovereignty of the state, security of the state, public order, decency and morality. So these are the reasons on which a reasonable restriction could be imposed. Now what do the facts say? The facts say IDBO is a public company, so it comes under the concept of state, sovereignty of the state as it is written over here. So IDBO is a public company incorporated under a statute by the legislature of Tamil Nadu. So it comes under the purview of state. The employees of the company made certain allegations against the director and officers of the company on grounds of corruption and maladministration. Fine, there were certain allegations against the director and officers for corruption. Employees made these allegations by giving interviews on various television channels and newspapers. They expressed that the chairman of the corporation should be removed from his post for not fulfilling his duties honestly. The government imposed restrictions on the employees from giving such interviews to news channels and newspapers. So we can see the restriction that was imposed was from giving such interviews to the news channels and newspapers. They did not say that you cannot make an allegation, but the mode of putting an allegation or complaining about the directors and other employees, only the mode was restricted. Now from the facts we can say that IDBO is a public company. So if such an interview is given on a television channel, there can be a public disorder. How can there be a public disorder? Because it's a public limited company, it would definitely have a lot of investment from other people. There would be a lot of shareholders, there would be other investors in the company, the entire stock market, there would be shares. So merely by giving interviews, the entire shares and all the functioning of this company would be in disturbance. So there will be a public disorder and the reputation of the company will also be harmed upon because of such a interview. So we can say that the principle says that reasonable restriction can be imposed on the right for certain purpose. And what the purpose they have listed down, such as in the interest of sovereignty of the state, security of the state, public order, decency and morality. So we can see that they have just put an imposition on the mode of government, mode of making the complaints or the allegations. They just said that the restriction on the employees from giving such interviews to news channels and newspapers. So that is why when we come down to question 92, which says to decide whether the restriction of the employees was constitutional or not. So from the facts we can see that such a restriction was constitutional, it was reasonable. And now what are the facts? Option D, which has been marked by majority of the students, says the government cannot impose restrictions on the employees as it was against fundamental right to speech. So we can say the restriction was not against fundamental right, it was reasonable. So D definitely cannot be the answer. C says the employees wanted to fight against the corruption and maladministration, hence whatever they spoke was in the interest of public at large. It's nowhere written that they wanted to fight against the corruption and maladministration, although it was in the interest of public at large. But the main reason from the facts we can deduce that what they wanted at the ultimate end was that these employees were getting indulged in corruption and maladministration. But what they did was not a correct method, because this would bring a lot of unrest in the public. Option B says the code of the employees undermined discipline and the efficient performance of IDPO, which was a basic code of conduct of employees, hence the restriction on employees was reasonable and constitutional. This cannot be a valid ground. Now option A says the conduct of the employees would not be in the interest of public order as their actions were detrimental to the interest of IDPO as a government entity. This option clearly says the reason which flows from the principle that such a conduct of the employee, it would not be in the interest of public order as their actions were detrimental to the interest of IDPO as a government entity. So therefore option A becomes the correct answer for question 92. Now in furtherance of this question we have question 93, which says would your answer change if one of the directors of the company was caught taking bribe in the sting operation? So in the first case there were only allegations, but question 93 says what if a person is caught in a sting operation? Still the answer would not change, because we can, the reason that we have mentioned in question 92 also, that the reputation of the company, the entire functioning of the company will get hindered, and because it's a state, comes under the purview of state, it's a public company, there would be a lot of unrest among the public also. So there will be public disorder which will be happening if people directly start giving interviews on television and newspapers. So that is why for question number 93 also the answer option is A, that the answer would not change. Now moving down to question number 94. 94 question was a question on the topic of torts. It was a fairly easy question, and most of the students have also marked the correct answer. The correct answer option is C, and majority of the students have marked C as the answer. The next question that we come down to is question number 95. It's a slightly long question, one of the difficult questions of the paper. Now, majority of the students have marked option C as the correct answer, which says the act is valid as it distinguished between Muslims and Hindus and provided that Muslims constituted a separate class of individuals who should be treated differently. The most important thing that has to be understood in this question is not deny to any person equality before the law or equal protection of the laws within the territory of India. Article 14 does not forbid classification or differentiation which rests upon reasonable grounds of distinction. Okay. Now principle 2 says a single individual may be treated as a class by himself on some peculiar facts or reasons applicable to him and not applicable to others. Principle 3 says state shall not discriminate against citizen on ground only of religion, race, caste, sex, place of birth or any. Principle 4 says personal laws are not subject to fundamental rights. One of the most important thing to keep in mind. Now moving on to facts. The fact says the government of India passed a Hindu Bigamous Marriage Act. Okay, an act which has been passed for Hindus, which rendered bigamous marriages void in India as well as criminalized the offence of bigamy in India. So the government of India passed an act for the Hindus which made bigamous marriages a crime, an offence, and it criminalized the offence of bigamy. The act, however, was not applicable to Muslims residing in India. So as the act was made for the Hindus, it was applicable only to Hindus and not applicable to Muslims. Mihir challenged the act on the ground that it resulted in discrimination of Hindus vis-a-vis Muslims. The allegations raised by Mihir were countered. Whatever allegations that were raised by Mihir, they were countered on the basis what? That Muslims constituted a separate class who should be treated differently because Muslim personal laws permitted men to have 4 wives. This is the important part of the facts. So we can see and we can gather from the facts that the government has started from the concept that they accept that Hindus and Muslims are 2 separate classes altogether, and they have made an act for the Muslims. For the Hindus, they have passed a statute, the Hindu Bigamous Marriage Act. They have passed this act only for the Hindus, which criminalizes the offence of bigamy. Now, as per principle 1, Article 14 does not forbid classification or differentiation which rests upon reasonable grounds of distinction. So the government has already knows that there is a distinction between Hindus and Muslims, and it is making some act for Hindus. So that is why the act will be valid because it is not differentiating between Hindu and Muslims. It already knows that there are 2 classes, Hindus and Muslims, and it is just making an act for the Hindus. Now, in the act that has been enacted, option C, which has been marked by most of the students, says that the act is valid as it distinguished between Hindu and Muslims and provided that Muslims constituted a separate class of individuals who should be treated differently. Now we have to understand that the act which is passed, that act is not making any difference between Hindu and Muslims, because that act is passed only for the Hindus to curb the offence of bigamy. The act is not making any difference between Hindu and Muslims. And the act, because it is made on the personal laws are not subject to fundamental rights. Therefore, there is no violation for against the Muslims. Therefore, the act which is passed is valid, and option D becomes the correct answer for this. That the act is valid as Muslim personal law allowed men to marry more than once. Now moving on to question number 96. Now question 96 was one of the easier questions in the paper, and B is the correct answer, which is marked by the majority of the students. Then moving ahead to question number 97. 97 again is among the easy questions and is based on the topic of torts, and the majority of students have marked B as the answer option, which is also the correct answer. Now we would come down to question number 98. Now question number 98 is a question which is based on criminal law, and it defines the offense of theft. Now when we read the principle, we can see that it says whoever intending to take dishonestly any movable property out of the possession of a person without that person's consent moves that property in order to such taking is said to commit theft. So let's break down this principle. First part is intending to take dishonestly. The person should be intending to take something dishonestly. Dishonest intention should be there. What? Any movable property. In what way? Out of the possession of a person. In what manner? Without that person's consent. And what does the person do? Moves that property. So we can see that there is first requirement, intending to take dishonesty, then second, movable property, third thing, out of the possession, fourth, without the consent, and fifth, moving that property. So these are the requirements which are there for an offense of theft. Now what does the fact says? The fact says Ajit and Amit are best friends. They're both good hunters and often go hunting together. Once, when they were out on a hunting spree, they made a shack for themselves. Amit was hunting from the shack while Ajit was sleeping there. Suddenly, Amit saw a big bear roaming around. Just as he took out his rifle, he realized that he had run out of bullets. So he took out the bullets from Ajit's bag with the intention of replacing them and shot 5 rounds at the bear. So we can see that he did not have a dishonest intention. He had the intention of replacing it back. The shots killed the bear. Ajit woke up, and after hearing the shots, and thereafter the two friends rejoiced together. After spending some more time in the forest, they went home. Amit completely forgot about the bullets he had taken from Ajit's bag. So is Amit liable for theft? The majority of the students have marked B as the option, which says no, Amit is not liable because he did not have the intention to steal the bullet, but merely wanted to kill the bear with the bullets. Then after that, the most number of students have marked A as the answer, which says yes, Amit is liable for theft because he had taken out bullets from Ajit's returning them to Ajit as soon as possible. So this option is clearly stating about the intention, the correct intention of Amit, and that there has been no dishonest intention. Therefore, option C is the correct answer. Option B and C are very close answers. So, among the two, option C is the better answer. Now, coming down to question number 99. Question 99 is again one of the very easy questions from the paper, and as most of the students have marked A, option A is the correct answer for this particular question. Now moving on to question number 100. Question number 100 has been a slightly doubtful question because most of the students have marked option A as the correct answer. In this particular question, the facts say that the Bihar government, unhappy with frequent demonstrations and bunds in the state, decided to issue a rule prohibiting government servants. So there is a prohibition on the government servants from participating in any demonstration in connection with any matter pertaining to the conditions of service. So we can see that there is a complete, absolute prohibition on the government servants. Option A says the rule is valid as it was enforced in the interest of public order since the demonstration and bunds interfered with peace and tranquility within the state. But we can see that the imposition, the prohibition that has been placed is an absolute prohibition. There is no reasonability. Principle 1 says that reasonable restrictions can be imposed on the right for certain purpose, and within certain limits, demonstration or picketing may be regarded as manifestation of one's freedom of speech and expression. But over here, there is an absolute ban, absolute prohibition of government servants from participating in any demonstration in connection with any matter. So therefore, the rule is invalid. So therefore, A and B cannot be the answer. Option C says the rule is invalid as demonstrations are valid in the eyes of law and the ban on demonstration was enforced in bad faith. This we cannot decipher from the facts. But option D says the rule is invalid and demonstrations form a part of speech and expression of the employees, which is true. That demonstrations, they form a part of speech and expression, and a complete ban, a complete prohibition is not the is not reasonable. So that is why option D is the correct answer. Then moving on to question number 101. Question 101 says it's a question on the topic of contracts, and most of the students have marked the correct answer, which is option C, that there is no valid agreement as the initial offer was rejected. Then moving on to question 102. This was also a very simple question, and again most of the students have done it correctly, and A is the correct answer, that he is guilty of rash and negligent driving. Now we come down to question number 103 and 104. Now again, among question number 103 and 104, we have a common set of principles and facts. Now, question number 103 says that does A's arrest amount to wrongful confinement? Most of the students have marked B as was also arrested on the orders of the superintendent of the police on charges of criminal breach of trust, which was a non-cognizable offence. And both of them were kept in police custody at the local police station for 24 hours and were produced before the magistrate, who dismissed the charges. During the period of detention, they were not allowed to meet their family members or their lawyer. They filed a complaint against the officials of the police for wrongful confinement. Now, wrongful confinement, the principle says whoever wrongfully restrains any person in such a manner as to prevent that person from proceeding beyond certain circumscribing limits is said to wrongfully confine that person. As we can see that both of them were arrested and put in the police custody. They were under certain circumscribing limit, so therefore there is wrongful confinement. But as most of the students are marked B as the option, we can see that the reason, that is, as attempt to murder is a cognizable offence, this has nowhere been mentioned in the principle or the facts. So this part is correct, that A's arrest, option B says A's arrest does not amount to wrongful confinement, as attempt to murder is a cognizable offence. Because this is nowhere written that attempt to murder is a cognizable offence, this cannot be the correct answer. So, from the facts, as we could see that he was arrested and put in a certain circumscribing limit, he was put in police custody at the local police station and he could not proceed beyond that particular area. This is clearly a wrongful confinement. So, therefore, A's arrest does amount to wrongful confinement. Then the next question, number 104, it says, does B's arrest amount to wrongful confinement? So again, yes, and most of the students have also marked this correct, that his arrest was carried on the orders of the superintendent of police for a non-cognizable offence. His arrest would amount to a wrongful confinement. So therefore, option A is the correct answer. Last, we would move on to question 105. Again, this was a debatable question. The question is on the topic of contracts, which says that when at the desire of the promisor, the promisee does something, it is said to form consideration for the agreement. Principle 2 says an agreement without consideration is void. The fact says that Philip was a fan of Hollywood movies. There was a new action movie being released on Friday, but there was no one to go with him. So he promised his friend Botan that he will cook dinner for him the next entire week if he goes to watch the movie with him. Botan obliged. That means he went with him, but he got very bored and left at the interval. When Philip returned, Botan asked him to cook dinner. Philip refused, stating Botan did not fulfill his part of the promise. Now, what does the principle says? Principle 1 says, when at the desire of the promisor. What was the desire of the promisor? Philip was the promisor. He said, I will cook dinner. So, Philip is the promisor. So, at the desire of the promisor, the promisee does something. Botan obliged. So, at the desire of Philip, Botan had done something. So, therefore, we can see that it is said to form consideration. So, consideration has been formed. It is nowhere said that